the WhitneyHarper versus Maverick Recording Company case in 2010. This case was originally discussed by a district court, and it was multiple record labels that filed it. So Maverick Recording Company is only one of them. The original download of 444 audio files, but the motion for summary judgment really only applies to 37 files that were deemed to copyright infringement. And the summary judgment was given to the recording companies, and it was allowed for $750 of each of songs, so in total $27,750. That's a typo. So my name is KCunha, and I'm here to discuss the WhitneyHarper versus Maverick Recording Company in 2010, the Supreme Court case. It was originally argued in the district court, filed for copyright infringement of the original 444 audio files, and it was filed for multiple record labels, including Maverick Recording Company. So the motion for summary judgment was granted on 37 files, and for each, the defendant would have to pay $750 for copyright infringement, which would add up to $27,750. Because the statutory damages in this type of case, when the infringer is liable, goes from $750 to $30,000, and if the proprietor of the actual content does not sue for more than the minimum, the case does not have to go to jury, so it can be decided in summary judgment. The defendant was a 16-year-old college student found guilty of infringement. At the time that she downloaded the song, she was actually a high school student, but at the time that the case finished, she was already a college student. She applied the innocent infringement defense, which could have reduced the minimum of the statutory damages from $700 to $200. So the court assessed that she would have to pay $200 per work because there was issues of fact whether she qualified as an innocent infringer or not. But the court also looked at section 504 on whether the infringer was actually aware or had reason to believe that downloading was illegal. Based on people who download music online have no access to the phono records, which are the album covers or albums where the copyright notice is posted. So that was the original ruling from the district court, which was appealed in a divergent interpretation, because they argued that this defense was foreclosed as a matter of law. Therefore, this happened based on two conclusions. One, that proper notice is provided on the phono records where the audio files originally came from before they were posted in these network sites. And then two, because the petitioner did not contest having access to these phono records under this section. So technically she agreed that she had seen the phono records, which are the album covers or wherever the CDs, and so she was aware that she was actively breaking the law. So in this interpretation, it was not necessary that the defendant sees the copyright notice, but it's available for them to find it on research or see it on the phono records. The Fifth Circuit does not specify in this case what a person has to show as an argument in order to preserve the defense of innocent infringer. The Court of Appeals also rejected her argument of youth and lack of legal sophistication as relevant considerations on the fact that she did not know that that was illegal and that she was doing copyright infringement. And the opinion in this case is that the conclusion may not be correct if the determinative question is whether or not the petition had reason to believe that her actions were illegal. The reason to believe is an objective standard, and it is not clear if the objective characteristics were actually accounted for, such as the defendant's age. So there is a strong argument that 402 section does not apply in a case involving the downloading of digital music files, because this provision was adopted in 1988 before digital music files became available on the internet. So then the case would come back to the 504 defense that the district court had originally awarded. But continuing on, the Fifth Circuit's decision may or may not set out a sensible rule for the post-phonorecord age, but it's at least questionable whether the decision correctly represents the Section 402 because of new technologies and the way that people now access music. And this is part of the opinion, so there are now no conflicting circuit decisions, but I would grant review in this case because not many cases presenting this issue are likely to reach the Court of Appeals. Court has not decided to grant review at this time, but if a conflict in the circuits develops in the future, the question presented, in my judgment, it is important enough to warrant a review. And in my opinion, I see that this is actually kind of wrong, because even though people may not see the notice of copyright infringement anymore when they download music online for free, that is a known knowledge that is everywhere in the internet for anyone to find. So in my opinion, I do think that 402 applies, and I don't think it's only because it is on the phonorecord, but because it is all over the internet as well. And then the related case based off of the first one that happened prior to this one is BMG Music Group versus Gonzalez. Cecilia Gonzalez had actually downloaded audio files from KCunha website, a total of 1,370 songs. BMG Music Group owned copyrights to these files, and they sued for infringement for 30 of these files because the defendant argued that she had not later paid for 30 of these, but had paid for the remaining audio files. Technically, the defendant had downloaded these songs to sample them and find out if she was actually interested in purchasing them later or not. However, you can see later in the case that does not mean anything in regards to downloading or not music illegally. So Section 504 sees the infringer liable, and the statutory damages go from $750 to $30,000, as does the last case, and any case in this in copyright infringement. The defendant, however, insists on fair use, which is a completely different defense than the last case, and she denies the premise of Grokster and Amster, which Grokster's premise was the distributed file sharing system is engaged in contributory copyright infringement when its principal object is the dissemination of copyright material. The foundation of this holding is a belief that people who post or download music files are primary infringers. This also applies for Amster because it was prior to Grokster. So the court disagrees that she used fair use and gave summary judgment to proprietors. Um, they awarded her damages $22,500 based off of the 30 songs that she not paid for, because they could not uh, consider the defense, the fair use defense, because she used the file sharing program to download music for free in order to decide if she wanted to purchase it later or not. However, in order to consider fair use, the court must take into account, and I decided to put all of this here just so that it's here, because it's a lot of information and I really didn't know how to summarize it. The first note that they need to consider fair use is the purpose and character of the use, including whether such use is for commercial nature or nonprofit, which, first of all, she's not engaged in nonprofit. Second is the nature of the copyright work, which is fully owned by other artists and not her, and it's music, so it's protected under copyright. The amount and substantiality of the portion used in relationship to the copyrighted work as a whole, and she downloaded the full songs, so she really doesn't qualify for that. So Gonzalez decided to use the fourth consideration, which would be the effect of the use upon potential market or value of the copyrighted work. She argues that downloading on a try before you buy basis is good advertising for copyright proprietors, which would expand the value of the inventory. But the Supreme Court disagrees because as file shares have increased, the sales of actual recorded music has dropped, and economic factors aside, these events are likely related. So music downloaded for free substitutes the purchase of them, and people may keep downloads and not buy originals, as Gonzalez did for 30 songs. BMG Music Group really only chose to pursue the copyright infringement case for 30 songs, but all of her 1,000 downloads violated the statute, undermining the way authors seek profit for their creative works. If Gonzalez had used the streaming radio music stores such as iTunes, like in iTunes you have an option for preview a song for 30 seconds, and they actually pay the artists those royalties to use the songs like that. So she could have actually chosen either way to listen to the songs before purchasing them, instead of infringing, and she would still be following the way the actual artist chose to profit from their works. With authorized previews as well, you can't keep a copy of the song in your computer after you stop paying for it, or after you just like listen to the preview, for example. With all these means available to consumers who want to choose where to spend their money, downloading full copies of copyrighted material without compensations to authors cannot be deemed as fair use. Copyers cannot argue that authors are wrong in the way that they choose to promote their work, or that Congress is wrong to grant them permission under this statute. Then Gonzalez argued for innocent infringer to reduce the awarded minimum from $750 to $200, but the court decided that, as the previous case, phono records are available online for people to see the warnings, and this information is available to research. So, therefore, they did not award that defense as valid. Later on, Gonzalez argues that a jury must decide whether the statutory minimum should be awarded according to Feltner, which holds a claim for statutory damages under 504 section. is a suit of law to which the Amendment applies. That, however, doesn't mean that every single case will have to be decided by jury. The court points out that when there are no disputes of material fact, the court may enter a summary judgment without transgressing the Constitution. Gonzalez then adds a case, Columbia Pictures Television versus Krypton Broadcasting of Brigham. But the case had more than the minimum statutory damages awarded for as the value, so it did not apply since BMG settled for the minimum. And then later on, she still argued that she learned her lesson and that everything should be dropped, and the court just did not agree. In this case, the opinion follows through with the actual court decision, and it demonstrates all the flaws in Gonzalez's arguments. And in this case, I agree with the court opinion because arguing for fair use in a case like this has absolutely no meaning. It goes against everything that fair use is about, as well as later on pointing out other cases that were decided in a different matter in order to defend herself did not make sense either. So Gonzalez's defenses really did not stand a chance against the proprietor's vision and what they were asking for when they filed for this case. Questions. So should the court have considered any of these defenses more than another, and why? Should reviews be considered in a case if they're based off old approaches to technology that is no longer used? And why could the court not consider Gonzalez's defense of fair use? And these are my references, and that's it. Thank you very much.